U.S. law as private merchant law, sovereignty, contractual jurisdiction, and national bankruptcy. 1. Introduction to private merchant law and contractual governance. U.S. law, in its operational form, functions under the umbrella of private merchant law. In this structure, citizens are effectively cast as both debtor and surety within the framework of a national bankruptcy. Because law in the United States is fundamentally contractual in nature, it is essential to understand the historical sequence of contracts and legal developments that underpin this legal structure. 2. Foundational legal agreements and national bankruptcy. The United States of America has operated in bankruptcy since at least 1788. Article 12 of the Articles of Confederation pledged the faith of the United States to repay debts contracted before the creation of the federal government. The Constitution of 1787 acknowledged and reorganized this debt in Article Virgin Islands. On January 1, 1788, the nation's bankruptcy was solidified following 21 loans from the King of England between 1778 and 1782. The U.S. Bank, established in 1791, was primarily owned by England. 3. The Congressional Quorum Crisis and Wartime Authority. A significant governmental shift occurred in 1861 when 7 Southern states left Congress, dissolving its quorum. Since then, Congress has operated under presidential war powers, citing emergency authority via statutes such as 12 Stat. 319 and codifications found in the U.S. Code. 4. The 14th Amendment and constructive trusts. The 14th Amendment established a legal framework characterized by constructive cestui trusts. This amendment created a binding legal relationship between individuals and the federal government, transforming people into corporate entities known as citizens of the United States. These citizens act as co-trustees and co-beneficiaries in a public charitable trust, merging individuals with the state under implied contractual terms. 5. The incorporation of U.S. government and state entities. In 1871, the United States government was formally incorporated as a private entity known as U.S. Incorporated. States followed suit, forming corporate analogs such as State of California. These entities serve as instrumentalities of U.S. Incorporated and collect taxes for international creditors. 6. Implied contracts and legal status. The U.S. legal system functions primarily through implied contract. These contracts are formed by silence, acquiescence, or by acceptance of government-provided benefits. Citizens who fail to rebut legal assumptions are presumed to have contracted into debtor/surety roles. 7. Civil death and legal incapacity. Under this legal fiction, individuals undergo a civil death, losing legal standing and control over their affairs. Their estates are managed in probate by government agencies. In this capacity, citizens are treated as collateral for national debt. 8. Transformation of citizenship and governance post-1865. Though the 14th Amendment was promoted as a path to citizenship for freed slaves, it extended to all citizens, reducing them to legal franchises of U.S. Incorporated. Over time, the government absorbed original state citizens into this jurisdiction. 9. U.S. Incorporated and financial insolvency. By 1912, U.S. Incorporated defaulted on its obligations. The Federal Reserve, a private banking consortium, assumed financial control. The federal government was thus absorbed into a financial system controlled by private interests, culminating in the Federal Reserve Act of 1913. 10. Creation of the Social Security Trust and legal fiction. In 1935, The Social Security Administration began issuing trust accounts using all capital letter names. These trusts are legally separate entities from the individual and serve to bind individuals to the status of co-trustee and debtor. 11. Integration into international financial institutions. The Bretton Woods Agreement of 1944 integrated the United States into the International Monetary Fund. This created a conflict of interest between the original government and its incorporated successor, with foreign entities managing U.S. financial policy. 12. State government incorporation and control. In the 1960s, U.S. governors incorporated their states into private entities. By 1970, all states operated under corporate charters, surrendering their original jurisdiction. The resulting legal framework replaced common law with administrative procedures and foreign financial interests. 13. Legal violations and constitutional breaches. Federal actions such as the 1994 Waco siege and biological testing under 50 U.S.C. 1520 violate constitutional norms. These acts demonstrate systemic overreach and disregard for individual rights under both domestic and natural law. 14. Citizenship as legal fiction. Government structures operate on the presumption that individuals have knowingly entered into corporate partnerships with state entities. Through silence or benefit acceptance, individuals assume roles as assets of a bankrupt corporation. 15. Path to remedy and sovereignty restoration. Legal maxim states, as a thing is bound, so it is unbound. Reclaiming sovereignty requires understanding how one became bound through legal mechanisms. With this awareness, individuals can begin to unwind the presumption and assert their unalienable rights. 16. Complexity and unreliability of modern law. Modern legal systems are vast and ever-changing. With over 2 million volumes in the Library of Congress alone, the law is inaccessible to the average citizen. Most legal decisions are rendered based on private law merchant principles, often unknown and unwritten. 17. Foundational questions about genuine law. Given these complexities, several key questions arise. Does timeless, stable, genuine law exist? Can it be invoked to protect one's birthrights? Why is it not taught? Can it be integrated with current legal structures? Natural law, aligned with divine law, punishes those who cause harm or take property. The restoration of genuine legal balance depends on individuals choosing to abide by principles that transcend corporate governance and commercial jurisdiction.